A valid contract is a binding line of obligation, holding two parties together under a specific, agreed-upon timeline. A breach is the exact moment that obligation fails, completely severing the connection and leaving the promise unfulfilled. Under the Indian Contract Act of 1872, this fracture functions as a specific trigger event. The law responds to this failure by activating a highly specific, conditional set of legal mechanisms engineered to restore balance. This legal decision tree maps out exactly how those mechanisms work, tracking every rule, exception, and remedy available to an aggrieved party. To understand contract law, we must abandon the idea of arbitrary punishment. The system instead demands we master a precise calculus of restitution and timing. The first major split categorizes a breach by exactly when the refusal occurs on the timeline. Under Section 39, an anticipatory breach happens when a party refuses to perform their promise strictly before the agreed-upon deadline has arrived. This early refusal can be express, communicated directly through written or spoken words, or it can be implied entirely by a party's conduct. If a promisor agrees to sell you their horse on August 10th, but secretly sells that exact horse to a third party on August 1st, their conduct alone implies an anticipatory breach. Section 39 gives the promisee their first strategic option. They can treat the contract as immediately rescinded and sue for damages right then, without waiting for the original deadline. Alternatively, the promisee can elect to keep the contract legally alive, wait for the original performance date, and hold the other party responsible then. But this second option carries a hidden risk. By keeping the contract alive, you give the guilty party a window to still perform or escape liability entirely if a supervening impossibility unexpectedly discharges the contract before the deadline. Contrast this scenario with an actual breach. This is a failure that occurs exactly on the scheduled date or a refusal made during the active performance of the obligations. The precise timestamp of a repudiation dictates the balance of power. It decides whether the innocent party controls the timeline of the lawsuit or assumes the risks of waiting. Zooming out on our diagram, 5 overarching statutory remedies drop down, becoming available once a breach is finalized. The first column shows that monetary damages are the default remedy, governed by the strict calculation rules found in Section 73. The core rule here is absolute. Compensation is only awarded for loss that naturally arises in the usual course of events. Remote or indirect losses are legally invisible. This principle originates from the landmark English case, Hadley v. Baxendale, which separated damages into 2 strict categories, ordinary and special. In Hadley, a flour mill's broken crankshaft was delayed by a carrier, grinding operations to a halt for days. Ordinary damages cover the direct, immediate financial difference caused by a breach. If a seller fails to deliver rice at the agreed 5,000 rupees and the market price has spiked to 5,500, the buyer can claim that 500 rupee difference directly. Special damages, however, cover secondary losses, like the idle flour mill's lost profits. These can only be claimed if the defaulting party was given prior, specific notice of those special circumstances. If a carrier delays a machine delivery, they must pay the average lost profits for the delay if they were warned the mill would stop. But they will not pay for the loss of a separate, lucrative government contract they were never told about. Foreseeability acts as the ultimate legal filter. The law refuses to hold a promisor liable for a chain reaction of financial ruin they could not have reasonably predicted. While Section 73 is compensatory, branching out from the damages column reveals rare scenarios where financial awards serve a different structural purpose. Vindictive or exemplary damages abandon the strict financial calculus. They are exclusively awarded for heavy emotional or reputational injury. Indian law recognizes only 2 strict triggers for vindictive damages: a breach of promise to marry and the wrongful dishonor of a customer's check by a banker. In Givens v. Westminster Bank, the court established that a trader can claim exemplary damages for a wrongfully dishonored check, purely for the loss of business credit, even without proving a single cent of direct pecuniary loss. Conversely, nominal damages are a mere legal acknowledgement. They are awarded when a breach technically occurred, but the promisee suffered 0 actual financial loss. Then there is a unique exception for physical goods. Damages for deterioration caused by a carrier's delay can be recovered without any prior notice. These edge cases prove that the law classifies financial awards strictly by the injury's nature, isolating reputational harm from mere technical defaults. Looking at a new major node under damages, we find Section 74. This governs prefixed damages, applying when parties write a specific financial penalty directly into the contract in case of a future breach. Under English law, courts draw a hard line. They will enforce liquidated damages, which represent a genuine pre-estimate of loss, but they will strike down a penalty, an extravagant, arbitrary sum meant to terrorize the other party into performing. But Section 74 of the Indian Contract Act intentionally flattens this distinction entirely. Regardless of whether a prefixed sum is labeled a genuine estimate or a draconian penalty, the Indian rule dictates that the aggrieved party is only entitled to reasonable compensation that does not exceed the stipulated amount. As the Supreme Court established in Shri Tuni Lal v. Mehta and Sons Limited, courts possess the power to reduce an unreasonably high penalty to a fair number, but they can never award more than the written cap. There is one primary statutory exception to Section 74: bail bonds or performance bonds given to the central or state government for public duties. If a government public duty bond is breached, the defaulter must pay the entire stipulated sum without reduction. Section 74 prevents private contracts from acting as instruments of extortion. It reserves punitive enforcement exclusively for matters of public interest. Panning past damages on our diagram, we arrive at the final 4 columns. These apply to scenarios where calculating financial compensation is impossible or entirely inadequate to restore the innocent party. Under Section 75, rescission is the rightful cancellation of the contract. It absolves the innocent party of all remaining obligations, while explicitly preserving their right to claim compensation for the failure. When money cannot buy an adequate substitute, a court may order specific performance. This forces the defaulting party to physically carry out the exact promise they made. An injunction acts as the exact inverse. It is a prohibitive court order that physically restrains a party from doing what they specifically promised not to do. A film star who signs an exclusivity contract but attempts to shoot with a rival can be legally frozen. Our final remedy is quantum meruit, a doctrine translating to as much as is earned. Unlike compensatory damages, quantum meruit is inherently restitutory. It allows a party who has completed partial work before a repudiation to claim remuneration for exactly the work they finished. For this doctrine to apply, 2 mandatory conditions must be met. The original contract must be entirely discharged, and the claim must be brought strictly by the non-defaulting party. These 4 equitable remedies ensure that the legal system can enforce justice through physical action and precise restitution, even when the math of financial compensation breaks down. A breach triggers an immediate classification based on time, dictating whether the promisee strikes immediately or assumes the risk of waiting. The law then forces a calculated pathway, navigating the foreseeability caps of financial damages or seeking the physical intervention of equity. The Indian Contract Act operates with absolute precision to restore the promisee, prioritizing restitution over punishment.